we'll set this for trial. He just admitted he's acting in self-defense. He is not admitting culpability to this. We're going to put this in trial and try these cases. I don't accept the deal.
This case is a legal roller coaster from start to finish. 19-year-old Cameron J. Smith is standing trial for a chaotic shooting incident that spiraled out of control. On one hand, prosecutors say Smith recklessly opened fire at an occupied vehicle, injuring someone and endangering an entire apartment complex. On the other, Smith insists he was acting in self-defense after the Mercedes he encountered pulled weapons on him first. The stakes couldn't be higher: felony charges, possible prison time up to 7 years, and a courtroom showdown that flips between remorse, denial, and raw emotion. Stick with us as we break down every shocking twist, from Smith's emotional plea for probation to the moment the judge calls him out for trying to play both sides. Trust me, you don't want to miss how this one ends.
It appears as though he entered his pleas in cause numbers 23 CR 2000, third-degree felony of deadly conduct, discharge of a firearm, and 23 CR 2001, the second-degree felony of aggravated assault with a deadly weapon. These occurring, it looked like, on or about the same date. And shooting at a vehicle and knowingly or recklessly causing bodily injury to another person. So shot at a fire, and he shot fire at a vehicle that was occupied, and somebody in the vehicle was injured.
That's correct, Your Honor.
Okay. And that's the second degree felony of aggravated assault, carved out two crimes out of one episode.
Yes, Your Honor. There was I apologize, Your Honor. I was just gonna get a court kind of breakdown of it if you would like. But
Okay. The defendant entered these pleas of guilty to these offenses on December 9th, 2024. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it?
No,
State
none from the state, Your Honor.
or defense?
Same, Your Honor. We've reviewed it. There's no corrections.
Then without objection, it will be part of the record. The agreement is whatever sentence shall not exceed a cap of 7 years in each case.
Yes, sir.
So
Here's where the legal math comes in. The plea deal sets a ceiling, a maximum of 7 years in prison for each case. But there's also the possibility of deferred adjudication probation, which means Smith could avoid a felony conviction if he plays by the rules during probation. Notice the detail. Regular probation is off the table because a deadly weapon was used. That's Texas law. Once a gun is involved, probation options narrow drastically. The defense knows this is their only chance to argue for leniency, and they're about to use every card they've got.
we're looking at two options, really.
Yes.
No less than 2, no more than 7 years confinement in prison for each case. Or deferred or unadjudicated probation. Regular probation, is it agreed upon, is not an option because a deadly weapon, namely a firearm, was used in the commission of these offenses.
That's
That's
correct.
correct.
Okay. Go ahead.
Your Honor, I do have a letter that my client has prepared for you if you want. It is evidence, or have him read it whatever way it's best. Do
Whatever you want to do.
you want to read it or you want to? Okay, we get that point. Hold on a second. We'll wait to get this one. So like me to go first or the state?
And again, you are Cameron Jace Smith.
Yes, sir.
And Mr. West is here representing you and the state's attorney is here. Okay, go ahead.
Your Honor, we are going to be requesting the probation, the deferred probation, in the sense that this is my client. He doesn't have any prior convictions, or felony convictions. This was an unfortunate incident. I'm not going to even justify that. It's unjustifiable, but it was a mistake he made, a horrible mistake he made. But I think he has been remorseful since then. He has a letter that he's written kind of talking about that. I would like to call him as a witness, have him explain some stuff to you so you can.
Raise your right hand. You solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Lower your hand. Thank you.
Thank you, Your Honor. Mr. Smith, go ahead and for now, you've written a letter to the court. Is that correct?
Yes, sir.
Go ahead and read it into the record so the court understands how your position. I think it's better than you just.
Now, this is the human side of courtroom drama. Smith reads his letter directly to the judge, apologizing, reflecting on his poor choices, and promising he's ready to change. He even adds that he just became a father again 2 days ago. That detail is strategic. Judges often weigh family responsibility and personal growth when deciding on probation versus prison. But here's the catch. Judges also look for consistency. If your words don't match the evidence, no heartfelt letter is going to save you. Question for you all. If you were the judge, would a letter like this sway you, or would you see it as damage control after the fact?
Speaking. Go ahead.
You know, I've been incarcerated. I had that time to think and reflect on my decisions and my choices. Something I have done to hold myself accountable. I'm not being noticed for making excuses for the way I'm doing my life. I can carry blame on this and that person or this person, but ultimately, it starts with me and the people I surround myself with. I'm at a point in life where I'm becoming a man, and I'm learning about myself every day. You know why? Your Honor, I want to give my serious apologies to the court and the victim for my actions. I would like to ask the court to make a harmful decision when determining my eligibility for probation and take into account the positive momentum I have doing despite not having the proper guidance. All people need sometimes is one more chance to put the best foot forward, and to go. Please allow me to show you and my family and myself that I can be a functioning member of society and not a hopeless man.
Okay, and also you just told me something a moment ago when we were standing here. Something that's happened since the last time we work, which was just earlier this week. What's happened since earlier this week?
I just had a daughter 2 days ago.
Okay, so is this your first child, or how many children do you have?
2 kids.
Do your community service?
So,
Pass the way, try.
Mr. Smith, on October 22nd, 2023, who were you there at that apartment complex with there, the Hamlet Park Apartments?
with my cousin,
And who's that?
Cameron Moon.
Were you also with an individual by the name of Victor Green?
No, sir.
And just prior, what kind of, did you have a gun on you that day?
Sure.
What kind of gun? Was it a handgun or a long gun? Did Cameron have a gun on him?
No, sir.
Who was walking with you towards this black Mercedes just before the shooting there?
I don't remember his names. So, sure.
Did that individual have a gun?
No, sir.
So you're the only one who had a weapon there?
Yes, sir.
Well, hold on.
This moment raises red flags. Smith admits he was with someone whose name he doesn't even know, yet they were together during a shooting incident? That's a credibility problem. Courts look for honesty and detail, but Smith's story sounds shaky. The prosecution will jump on this. If you're asking for probation, you need to show responsibility and transparency, not confusion about your own associates. Think about it. How often do you just meet someone and within hours end up in a shootout? It strains belief. The judge is already picking up on these contradictions.
How did you come to know that person who's unnamed, that you don't know, whose name you don't know, but yet you're involved in shooting with some people in the car, and you're with somebody and you don't even know their name? Who's that, and how did that happen?
It was just.
You have to speak up
Yes,
so
sir.
she can hear.
It was me being with my cousin, and I was with one of his friends, but I don't like know his real name. Well, I just met him that day. So me just being with him, me being in the wrong place for a long time.
Okay. Go ahead. So the other individual that's were you ever walking towards this black Mercedes vehicle?
No, sir.
How did how did you start shooting?
Because the Mercedes pulled behind me and started shooting at us first.
I have no further questions, Your Honor.
Real quick, I just don't want to clear something up, Your Honor. I think that it's clear, but I want to make sure. This other individual that you don't know, it was a friend of your cousin's, correct? So you were there with your cousin.
Yes, sir.
Okay. So you just met this person that day.
Yes, sir.
Okay. Not a friend of yours, not a relative of yours. or you know you had no contact except for the fact that he was your friend of your cousin. All right, that's what it's. Nothing more.
Nothing further. No other question.
So, where'd you get your firearm that you were shooting at the car with? Think about it.
From Frank Houston.
Who?
Um,
He's a friend of yours. You don't know his name?
his name is Josh Moore.
Hmm?
Josh Moore
Where does he live?
from Houston.
Look, I know 2 million people are in Houston. Where in Houston does he live?
From Southwest Houston.
Okay, so why did you have a firearm with you? At 19, you're 19 years of age when this happened, right?
Yes, sir.
Then what are you doing carrying around a firearm shooting at cars? Is it something to do in Beaumont?
No, sir.
Oh,
I don't think it was a good decision. Either.
I looked at all the paperwork here and um,
Here's where things get messy. Police recovered multiple firearms, shell casings, and even rifles tied to the scene. The judge bluntly asks, why was a 19-year-old carrying a firearm and shooting at cars? This is no small-town mischief. Stray bullets hit apartments and nearby homes. Imagine being a neighbor, sitting at home with kids inside, when bullets rip through your walls. That's the kind of public danger judges can't ignore. This testimony highlights why prosecutors are pushing hard for prison time. It's not just about one victim, it's about community safety.
we found all kind of guns where he was hiding, a rifle, handgun, shell casing. Who had the rifle? Y'all had a rifle. Who had that?
That's when the Mercedes started shooting at me first. You know what I mean?
Your Honor, what the witnesses described in the Mercedes and a witness who was nearby described two individuals walking towards that black Mercedes with weapons out, which one of them was a handgun, which we believe was Mr. Smith, as well as the other individual had a long gun.
Is that right?
No, sir.
Nobody had a long gun?
The only two people that had long guns, the two people that came out the Mercedes shooting at us. You know.
I'm sorry, but you had a gun.
Yes, sir.
And Your Honor, the witnesses who were in the Mercedes said that they pulled near a dumpster turnaround there, which one of the individuals in there lived at those apartments, and they saw Mr. Smith as well as a Victor Green, who had formerly dated one of the individuals in the car, walking towards them with guns. The two males in the back of that black Mercedes jumped out with guns as well, which were long guns. And they said that
Who's
both,
they?
I'm sorry, it was Faith Simon as well as the complainant here, Jayla Charlotte. They were in the vehicle along with a Daniel Harvey Jr. and a Joshua Slaughter. So the two females, Miss Charlotte, Miss Simon, stated that both Joshua Slaughter, and Daniel Harvey Jr., upon seeing these individuals walking towards them with guns, jumped out with their own guns. And they described the individuals walking towards them started firing, and shortly after, they returned fire. They were the ones who contacted the police. The other individuals that were there, it wasn't Mr. Smith nor Mr. Green who were involved in that. And they found police found Mr. Smith hiding there in the little fenced-in area of one of the apartments right there, and there was a handgun hidden in the bar, I believe the barbecue pit right there, 9mm. There were also several apartments that were hit, Your Honor, with stray bullets. No one there in the apartment complex was injured, but there's also a nearby home that was struck with the bullets. So it was quite dangerous. Yes, Your Honor.
This section is crucial. Prosecutors' present eyewitness testimony, people inside the Mercedes and nearby witnesses all describing Smith and another individual walking toward the car with weapons drawn. The defense wants the judge to believe Smith only fired back in fear, but multiple accounts suggest he initiated. And remember, it's not just what you say, it's what the evidence shows. Hidden guns, conflicting testimony, and injured bystanders don't exactly scream self-defense. At this point, the courtroom tension spikes. Which version do you believe? The remorseful father asking for probation, or the armed young man who endangered an entire complex?
Okay. What are you asking for?
Your Honor, I believe
I see what I see what the deal is.
Yes,
What are you asking for? I would just say.
I believe the 7 years is appropriate. There was by going ahead and taking it upon itself to then start firing first and create this situation that could have killed or injured lots of people there at the apartment complex. Your Honor, I believe that warrants that kind of activity, and doing those things warrants every bit of the 7 years. They actually, took a step further rather than just having the gun. They went there and started firing, and could have injured not only the individuals in the car more severely, they also everyone around, kids,
Could kill people.
people living there. Yes, Your Honor.
Okay. So I just want to get this clear. Why were you shooting at, what's your final answer here? Why were you shooting at God bless you, at the car?
Honor.
Hmm?
Your Honor,
Mm-hmm.
I didn't shoot at the people jumped out with the sword, what they saying. I don't want to put the blame on nobody else. Because I know I'm in the wrong for them being there, Your Honor. And I'm taking accountability of my actions.
No, look, you're charged with deadly conduct.
Like,
That's discharging a firearm in each of these cases at people without good cause. Why were you firing the gun?
Because two people, I'm walking in the apartment, Your Honor,
Why did you shoot the gun?
and two people get out the car and get to shooting at me.
First?
Yes, Your Honor. He
Why?
was shooting at me first.
Okay.
And here's the turning point. The judge is not buying it, but because you can't plead guilty, ask for leniency, and then claim self-defense in the same breath. That's a contradiction. A guilty plea means full acceptance of responsibility, no excuses, no justifications. The judge sees Smith's words as undermining his own plea deal. Bottom line, if you say you're guilty but argue you only acted in self-defense, the judge hears two stories at once. And in court, credibility is everything. That's why the deal is scrapped and the case is set for trial.
We'll set this for trial. He just admitted he's acting in self-defense. He is not admitting culpability to this. We're going to put this in trial and try these cases. I don't accept the deal when you're looking at me and telling me that you're doing it in self-defense. That's not accepting responsibility. Here, it's set for trial. That deal is off.
So let's recap. Cameron J. Smith faced serious felony charges, deadly conduct, and aggravated assault with a deadly weapon. His defense fought hard for deferred probation, highlighting his lack of prior felonies, his remorse, and his new role as a father. But the evidence told another story: multiple firearms, injured victims, and testimony suggesting he escalated the violence. In the end, the judge rejected his guilty plea deal after Smith tried to frame it as self-defense. That's the price of mixed messages in a courtroom. You can't admit guilt while denying blame. This case is now headed to trial, where the stakes are even higher. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.